Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation. This video is going to continue our series looking at House Bill 837 that was passed on March 24th, 2023 in Florida. Our first video looked at the effect on the statute of limitations for negligence claims in Florida. This video, we're going to look at the change from a pure comparative fault scenario to a modified comparative fault situation. If you have questions on the difference between comparative fault, pure and modified, or contributory negligence states, take a look at our videos on those topics specifically. In short, a pure comparative fault state will allow a party to recover their damages no matter how much at fault they are. Their damages are just reduced by their percentage of fault. So if you're 90% at fault for running a red light, but the other party that was in the accident was 10% at fault for speeding, you can still recover 10% of your damages against that other at-fault party. Modified comparative fault stops a party from being able to recover when their negligence exceeds a certain threshold. In Florida, House Bill 837 changed it so that if a party is more than 50% at fault for their damages, they can't recover from any other party. This is a significant change in terms of when a party could recover in cases where there's a claim that both parties are at fault. So just as we asked under the statute of limitations video, how is this going to affect your existing subrogation claims and those that occur in the future? Section 30 of House Bill 837 did address this issue, and it stated, except for the statute of limitations provision, that the effect of the law was going to apply to cases that were filed after the law became effective. So March 24th, 2023 is our deadline. Apparently, under the House bill, any cases that were pending prior to that date would still be under the pure comparative fault situation, and the law would look only forward to those new cases to apply the modified comparative fault rules. But things are never as clear as you think they might be. It's the legal world. So we have had some cases come out already where courts are looking at, no, maybe despite what they say that the modified comparative fault is going to apply to cases going forward, courts in some counties are beginning to say, no, this should apply retrospectively. And the analysis that you go through in Florida to determine whether a law should apply prospectively only or retrospectively is to look at what type of law it is. Is it a substantive law that creates the rights and responsibilities of the parties? Or is it a procedural law that sets forth how those rights are enforced? If it's a substantive law, the court will first look to see, was there any clear legislative intent about whether it should be retrospective or prospective only? And there's a bias or a default position that the legislative body is going to make laws that apply prospectively only. So the courts are looking for something very clear in the statute that says, no, this is going to apply backwards. If they do find that there's some express intent for retrospective application, then the court is going to look to see whether the legislative body had authority to make that law. Was it constitutional for them to do so? If it's a procedural rule, the court just looks to see whether or not it makes sense to apply retrospectively, regardless of what the legislature says. And an early case where this was discussed on this issue of House Bill 837, a different provision than what we're talking about here, but the court went through a pretty in-depth analysis and looked at Florida's specific separation of powers and found that it's not just at the federal level where each body has their own independent functions and oversight over the others. In Florida, if it's given to the legislative body, then the judicial body can't touch it. And if it's a judicial function, then the legislative can't touch it. And so they're taking a much stronger approach to that separation of powers. So we have had one case already that came out and said that that portion of House Bill 837 was a procedural law, and it made sense for the court to apply it going backwards. So even though the lawsuit had been filed almost 10 years prior, the court was going to apply the modified comparative fault statute that now exists after House Bill 837 was passed. Now, there's another case in Sarasota where the court just pretty simply said, and there was no long opinion, that it's not going to apply the modified comparative fault retrospectively. So what does this mean for you? This confusion, this murkiness, what do you do? Well, just before this bill was passed, there was reportedly a large push by plaintiffs' firms to get lawsuits filed. Part of it has to do with some of the damages rules that have now changed, but some of it has to do with comparative fault. And if you're a plaintiff, you want to have a pure comparative fault standard, because even if you are found more than 50% at fault, you can still get some damages back. Under the modified, it's a lot less likely, if there's that dispute, that you're going to get a recovery because there's that 50% threshold. So if those parties had filed those tens of thousands of lawsuits to try and get in under the pure comparative fault status, and now courts are going to say, well, it doesn't really matter what the bill says, we're going to look backwards anyway, it certainly has created a lot of confusion. But if you have a claim where you have already filed suit, get ready for that claim that modified comparative fault should apply. If you have not filed yet, then it's clear that the modified comparative fault is going to apply in that case going forward. And you need to consider that when you're assessing whether your insured has some fault in the loss and the likelihood of recovery as you decide to proceed. So this is a pretty touchy situation in terms of we don't exactly know how it's going to turn out and where the courts are exactly going to land, but we are keeping an eye on it. And if you have any questions on whether or not a case you have is a good case and one that would justify litigation based on possible relative fault of each of the parties, don't hesitate to reach out to us. For On Subrogation and Rathbone Group, I'm Jason Sullivan, and that's the long and short of it.